Good day viewers, I am Sushila Ram Varma, Chief Consultant at the Indian Lawyer and Allied Services. Today we bring to you TIL Legal Tips Episode 3. This episode will be dealing with a very important clause in all contracts, namely the dispute resolution mechanism. What are the types of dispute resolution? In our Indian legal system, there are 4 types of dispute resolution. The first is negotiation, where parties have the option of talking to each other and settling their difference. The second would be mediation or conciliation, which are recognized forms of settling disputes under the Indian Arbitration Act. If these fail, there is a third option called arbitration. It can either be a domestic arbitration or an international arbitration, depending on the parties. And finally, the last option that is available to all litigants is the approach to court, which is you go for litigation. The next question would probably be, how does one decide a dispute resolution clause? The answer is simple. It would all depend on the nature of the contract, that is, what is the subject matter of the contract, and how the parties would like to resolve it, and also where the parties would like to resolve it, and the most important thing, what is the law under which they would like to be guided in resolving their disputes. Another very important question that arises is, what is jurisdiction and how does one decide it? Well, it is important to decide the correct jurisdiction. Invariably, when parties are from 2 different countries, they want to go for a neutral jurisdiction in order to ensure independence and impartiality. Hence, they choose a third country which is not connected to their place of working, and they feel that this will help them to get impartiality. The next question, which is very important, is what are the steps that have to be followed in a dispute resolution? Ideally, I would say a 3-step process should be followed, which is negotiation, where parties try to decide things amicably. If this fails, appointment of a conciliator or a mediator who helps the parties to resolve their disputes. And if this fails too, then arbitration or litigation, depending on what the parties have decided for settling their disputes. In today's day and age, the digital world has become the real world. Contracts are finalized in the digital world, sometimes by exchange of emails, exchange of terms, etc. But in many cases, especially when we are using a website, we tend to enter into a contract which is known as a click-wrap or a click-through agreement. What is this? This is an agreement where when you are using the website, you say I agree. Clicking on I agree binds you to a contract that you have signed online. Hence, it is always advisable that you should read through the contract very carefully before you click on I agree. The last question is, which is the best form of dispute resolution? A very difficult question to answer because each party would have a different mindset. But in my opinion, negotiation is always the best form of settling matters, but both parties must be pragmatic and must realize that they have to look at the larger picture, which is their business interest. If this fails, then I would say even mediation or conciliation, where a third party sits to help you to get to closure on your dispute, is a good option. Well, if this fails, you have no option but to go for arbitration or for litigation, which may then take up years of your time. If you have found this video helpful, please like and subscribe to our channel and help us to spread legal tips, which is a very important aspect of our day-to-day transactions today. Thank you and bye.